the judge was allowed to commit them to mental institution. And that law, or it wasn't a law, but the rule also said that it was the judge who was the sole person able to rescind that order or to release them. So even if they didn't seem insane anymore, if it went back to the court and the judge, saw them as still manifestly dangerous to society, could say, no, this person is going to stay in the mental institution. And that's sort of what happened. Without this, it was literally enacted like 2 months before this rule was enacted. If this rule had been enacted and the judge had not committed him at least to an insane to the Florida hospital, it's likely that Powell would have walked free that day. Okay, and so he didn't. Thank God.
So when you hired Arnold Levine, did you think that he was going to be able to free your brother?
No. I mean, it's clear-cut, outrageous murder. Witnesses, shell casings, everything you can imagine. No, I didn't.
You were looking at this as you were giving somebody the equivalent of today, like $800,000, thinking that it was just up in smoke?
Yeah.
You thought that was going to be the end of the money and you were never going to see it again? And
I figured he was going to get convicted and it'd be over with. And then he'd go away for 20, 40, 50 years. Something like that. I never thought that he was going to get temporary insanity.
So if your family had pressured you to pay for the defense, you do feel that he would have spent probably the rest of his life incarcerated?
Yes.
Do you feel in any way personally responsible for the overall outcome? And I mean, your brother being released, but also changing the laws, federal law.
I do, because I did it, but I did it because of this family concept, I mean, anybody with a family is supposed to be supporting all their brothers, but I didn't do it for Jimmy. I did it for my other brothers and my mother, fuck Jimmy, if I didn't know he was going to kill Karen Jolley, I'd have done something,
I think that the big question here is how did this guy end up walking free eventually? Okay, and that's really what we want to investigate. In 1971, the year before this tragedy occurred, Florida passed a law. It was called the Baker Act. Now, this is legislation. This is real legal framework. And it was never intended to have anything to do with anybody that had been charged with a criminal offense. What the Baker Act was designed to do was protect the rights of people who had been committed to an insane asylum and then essentially saw their rights disappear. This happened all the time. Remember, it was in the 1970s and earlier. What the Baker Act wanted to do was just say, look, if you get committed for some reason, and especially with older patients, dementia, people who aren't really insane, it's like maybe they need some treatment, but they should be released. And what was going on before the Baker Act was passed is that, people were dropping off, their older relatives or whomever and dropping them off at the asylum and saying they're crazy. And there was no way for those people to get a lawyer and get out. And so the Baker Act, this is what it was for. It was for civilly committed patients to retain their rights, to challenge being in an asylum. Judicial Rule 3460 that came in right before the trial, the reason that was created, it had nothing to do with Jimmy Powell. What it had to do with was the potential for abuse of the Baker Act. The Florida, judicial system recognized that, hey, there could be a little bit of trouble here. And so they created this judicial rule, and it was hasty, and it was abandoned, and it was not meant to deal with this in the long term. A judicial rule gives a judge leeway to make a judgment call. It's not a comprehensive framework, okay? And so while he was able to use this 3460, this new Band-Aid, this judicial rule, it was not a law like the Baker Act was. So within 6 months, the administrator of the Florida State Hospital in Chattahoochee comes back and says, you know what? This guy's not insane anymore. Really, all you need to know here is that the Baker Act and Rule 3460 had two very, very different standards. And the one that, and really the Baker Act, I'm not going to go through every one of these, but the Baker Act said, you know what? The healthcare professional can make a determination and release this person. Rule 3460 says this person has to actually be released by the judge. The judge is the only person that can release them. And that's the way that it goes. So Levine, the trial's over now. This is done. This is 1973. It's a little bit later. Levine recognizes that there's a problem here from a legal perspective, and that is that you can't treat somebody differently just because of the fact that they had run through the criminal justice system. He was not guilty, right? So Levine recognizes this, and he recognizes that it's literally a constitutional issue. He says, look, you can't keep this guy locked up. He's not insane. The doctors have said he's not insane. He's not guilty. Levine takes his appeal, and it goes all the way to the Florida Supreme Court. Levine is a state court lawyer, defense attorney, and he loses the appeals. Finally, after, a couple years, makes it all the way up to the Florida Supreme Court. Florida Supreme Court still upholds him being held in Chattahoochee. Okay? The Supreme Court, with only one dissenter, said, this is our rule, and the judge has the ability to make this choice, and that's the way it is. So Levine was at the end of his rope. So they gave the case actually to a different local attorney whose name was Bob Olay. And Bob Olay, he was a constitutional defense attorney. This was his specialty, was federal criminal stuff. Levine had no experience with federal appeals or anything like that. So Olay takes it, instead of state court, he takes it to the federal court of appeals, right? And he says that under the Equal Protection Clause of the 14th Amendment, you cannot hold one person in an institution differently than someone else. That's what equal protection is. It means that the law is blind, and if on paper, if the things are the same, if the situation is kind of the same, you can't do that. And this judicial rule was part of the problem. It's like if there had been a law around this, then that would have been different. But this was a subjective rule that was keeping Powell incarcerated, not incarcerated, but, confined at Chattahoochee. The Fifth Circuit Court of Appeals, they agreed with Olay. This is the guy that actually got Powell free. It wasn't Arnold Levine. Arnold Levine got his sentence, but he remained in Chattahoochee the whole time that Levine was his lawyer and going through this. Olay took it to the, when he took it to the Circuit Court, Court of Appeals, that's who won the case. April 1975, the case is going through, we're backing up in time just a little bit. The appeals case is going through the Florida process with Levine. There's a guy named John Caminez, and Caminez was hired by the state of Florida back in the mid-70s to actually review cases that were compelling release for people under the Baker Act. Okay? So he was like, really what his job was to look at these cases and say, yes, this person should be released because under the Baker Act they can't be held. And so that was what he was supposed to do. And he went on to become a prominent attorney in Tallahassee. He was very successful, and this is a great guy. But this is like that guy who's kind of like the rabble-rouser. He was not going along with the establishment, right? And so he writes this report in 1975 because he recognizes that, there's a lot of problems with the Baker Act, and at this point, Jimmy Powell hadn't been released yet, but he's saying, like, look, he could be. And he writes this scathing report, and he literally uses the Powell case as the example, right? He said, look, Powell had tactical sanity. You can't use a staircase as a barricade and identify a victim as her, because it's showing cognitive awareness and goal-oriented behaviors. He wrote that insane people don't seek tactical cover, and they don't identify hostages by gender. He said, this guy, he's not insane. He wasn't insane at the time. And he said on top of that, political shielding, Lynn Andrews, he says, if powerful figures can sever an eyewitness from the original honest statement, the legal system's truth-seeking function of a trial is paralyzed. And he's right. He was saying, like in not so many words, this is corruption. This was a cover-up. And this was the guy that led that charge. And along with that, he said, if the cocaine theft had been admitted into evidence, the defense would have been unable to even claim that Powell was insane. Because Stitt's statement got suppressed, there was no motive. So there was no way for the prosecution to argue. They couldn't even talk about Stitt stealing the cocaine. And then finally, he says, the Baker Act, it's not meant for people who are temporarily insane that commit murders. It's not for that. But the lawyers twisted it around, and they forced it to be applied in this case. And he said, this was being used as a shield. And he said, how is it this guy is insane enough to go on this rampage that he doesn't remember and kill people and scream and all of this, but then sane enough for the doctors to recommend that he's released less than 6 months later from an institution. So Caminez really hit the nail on the head. So this is it, my last slide. What happens? And it really comes down to this. Political influence met an immature legal framework. Stitt committed a perjury of omission when he didn't talk about stealing coke. And the exploitation of the Baker Act meant for civil patients was wrong. And because the not guilty by reason of insanity standards at the time, because the Baker Act had come out and all this, it created a constitutional conflict. So, I told you you're not going to feel the best at the end. Were there lasting changes? Yes. Put in force back in 1978, right? Or 1980. It was called Florida Statute 916. What Florida Statute 916 does is it creates an entire legal framework for people who are not guilty by reason of insanity. And it says if they're going to be released, they have to literally have this process. But it's a formal process. It's not a judge's arbitrary decision. It is a process by which you move through a system. And it also says if you are insane enough to not stand trial, you don't. You get committed until you can stand trial. And then we are going to, have the trial when you're sane. So so 916 closed the loopholes, and it made it so that what happened with Jimmy Powell and his release could not ever happen again. But here's the kicker. 916 laws, Chapter 916 is now being challenged in Florida. And the reason why is because the system is completely backlogged and overcrowded, and people are being held in squalid conditions. There's not enough room to hold these people. They're not moving through the system fast enough, and the process is no longer working. So I've got my eye on this. I'm going to be interested to see what eventually happens. But this law that's went into place, almost 50 years ago now, is being challenged again. So anyway, failure of justice, moral injustice, flawed system, corruption. That's what happened.